Today, before the sun came up, before the news cycle began, before the talking points were written, before anyone had a chance to spin what happened, the law acted. At exactly 9:00 a.m. on January 23rd, a federal judge issued an arrest order, not for a protester, not for an undocumented migrant, not for a low-level government employee, but for a sitting cabinet official of the United States government, Kristi Noem. And the reason was not politics or ideology. Immigration and Customs Enforcement agents carried out an early morning operation, entered a residential space, detained a family, and took into custody a child who was 5 years old. No criminal record, no threat, no capacity to resist, no understanding of what was happening. That is not a policy debate. That is a fact pattern. And that fact pattern landed on a federal judge's desk. Judges do not watch cable news. They do not attend rallies, and they do not measure the popularity of their rulings. They read affidavits, review sworn testimony, and examine whether the government followed the law. And the court saw something that crossed a line. Not a gray area, not an administrative error, but a clear violation of constitutional protections afforded to minors. Due process, protection from unreasonable seizure, and the most basic principle of all, that the state's power has limits, especially when it comes to children. The ruling did not say, end immigration enforcement, and it did not say, open the borders. It said something far narrower and far more devastating, that no official, no agency, and no political agenda can justify the detention of a child in this manner. That is not activism, that is constitutional law. It is the difference between policy discretion and constitutional constraint, between what an agency wants to do and what the law allows it to do. And that difference is the backbone of the American system. Kristi Noem was not arrested in this scenario because of rhetoric, a speech, or her politics. She was arrested because the court determined that she exercised authority, or failed to restrain authority, in a way that directly led to unlawful harm. That distinction matters because courts do not arrest people for beliefs. They arrest people for responsibility, and responsibility flows upward. It does not stop at the field office. It does not end with the agent on the ground, and it does not disappear because the chain of command becomes politically inconvenient. Imagine the moment itself. No cameras, no crowd, no spectacle, just federal marshals executing a judicial order. That quiet matters because the most powerful moments in a democracy are rarely loud. They are procedural. They are calm. They are final. In that moment, the court was not speaking to Kristi Noem alone. It was speaking to the entire executive branch, reminding it that authority does not outrun accountability and that titles do not override the Constitution. This moment tests a question America avoids asking. What happens when the law finally treats powerful officials the same way it treats everyone else? For decades, immigration enforcement has existed in a moral gray zone. Broad discretion, limited oversight, and almost no accountability at the top. That gray zone has swallowed families, separated children, and normalized actions that would be unthinkable in almost any other context. This moment ends that arrangement, not with outrage, not with slogans, not with a press conference, but with a warrant. The Constitution does not say that due process applies unless the person is small, frightened, and undocumented. It does not say rights depend on age or citizenship. It says persons. Children are persons. And when the state forgets that, courts are supposed to remember, that is their job. The reaction is immediate and predictable. Some politicians call it tyranny, others call it treason. Still others warn of chaos and collapse. But notice what none of them do. They do not argue the facts. They do not argue the constitutional analysis. They argue power. They argue precedent only in the abstract. They argue what this might mean for authority if it is allowed to stand. And that is how you know the court struck a nerve. Because when the facts are solid and the law is clear, power has nothing left to argue but itself. Judges do not need to win elections. They do not fundraise. They do not poll test rulings. They are insulated precisely for moments like this, when enforcing the law angers powerful people who are accustomed to deference. If judges were political actors, this ruling would never happen. If they were calibrated to public opinion, it would be delayed, softened, or avoided entirely. The system worked because it was designed to resist pressure, to absorb outrage, and to act anyway. This ruling does not dismantle ICE, it restrains it. It says enforcement does not override humanity. It says operational authority does not erase constitutional limits. And most importantly, it says that just following orders is not a defense when those orders violate the law. That principle is old, settled, and non-negotiable, even when it becomes inconvenient for those in charge. But this moment does more than restrain an agency. It redraws the map of accountability. It tells future officials that legal memos cannot launder unlawful conduct, that internal approvals do not nullify constitutional protections, and that urgency does not excuse excess. It forces a recalibration inside government, where risk assessments shift from public relations fallout to legal exposure, from political blowback to personal responsibility. And that recalibration matters, because systems change not when values are debated, but when incentives change. Throughout all of this, there is a child, not a symbol, not a talking point, not a statistic in a briefing, but a human being, 5 years old, unable to understand borders, sovereignty, or why adults with badges took them away. That child is the measure of this moment, because if the law cannot protect that child, it cannot protect anyone. What makes this moment so unsettling is what it suggests, that the era of consequence-free governance might end, that authority does not immunize, that courts can still say no, and that when they do, the executive branch must listen. The arrest is not punishment, it is a boundary. It says clearly and unmistakably, this far and no further. Boundaries are what keep democracies intact. Without them, power expands until it consumes the very rules that once restrained it. If this moment holds, future officials will hesitate. They will ask harder questions of their lawyers. They will demand clearer justifications for aggressive tactics. They will reconsider decisions made in the dark, in the early morning hours, far from public view. They will insist on safeguards that slow things down, not because delay is desirable, but because speed without legality is dangerous. They will remember that children are not leverage, not tools, not collateral, and that hesitation will not be weakness. It will be the law working as intended, inserting itself between power and harm. This moment also reframes public debate. It shifts attention away from slogans and towards standards, away from partisan reflexes, and toward constitutional baseline. It asks citizens to consider not whether they like the outcome, but whether they accept the rules that produced it. Democracies endure not because outcomes are universally popular, but because processes are broadly respected. And respect for process is what the court is defending here, quietly and without flourish. The real question raised is not whether Kristi Noem should be arrested in this fictional scenario. The real question is why it feels unthinkable when powerful officials are held accountable, while it feels normal, almost expected, when powerless people are. That imbalance is the story. It is the quiet assumption that authority deserves patience and deference, while vulnerability deserves suspicion and force. It is the asymmetry that corrodes trust and erodes legitimacy over time. The court did its job quietly, carefully, and without fear. It did not announce itself. It did not seek applause. It did not explain itself to the outrage machine. It simply acted. And in doing so, it reminded the country of something we are in danger of forgetting. The law does not exist to protect power. It exists to restrain it, especially when power comes for a child. Because if the courts cannot stop that, then the law is no longer the law. It becomes just another instrument of force, another tool of convenience, another mechanism by which the strong impose their will on the weak. And democracies do not survive that. Not loudly, not suddenly, but quietly, one early morning at a time.